Welcome to DR TSPR show. This is
Ravi,
Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello, and a warm,
one
warm
second.
welcome to
We'll
Ravichandran
first.
Swaminathan ji from Coimbatore and Rajendran ji. He is a retired banker from Chennai. We are discussing topic electoral bonds. Are there junk bonds? Quid pro quo? Why SBI, in spite of so much of time, failed to reveal or make it public in spite of Supreme Court order in February itself. Again, Supreme Court had to take the contempt petition filed by the organization represented by senior advocate in Supreme Court. Only then, when Supreme Court clearly stated that by this time you have to publish, that was yesterday, 12th evening, bank time, all those information related to electoral bonds should reach Election Commission of India. And in compliance, State Bank of India has furnished total information. Now I will show you as per the Supreme Court own official website. Why State Bank of India did not do it before asking for time till June is a mystery. Is this going to affect Mr. Modi's government? And not just BJP. Every party has got electoral bonds. Through this channel, me, Ravichandran ji, we were shouting from the rooftop. Why should there be a secrecy of those organizations who are using resources? Individuals, we said they should be allowed to be free to share, because as an employee, if I am working in a certain government agency, if I am funding another opposition party, if I am sharing it out of my own will or volition, I will be targeted. This is where me and Ravichandran, we were differing with the Supreme Court order. It should be not be a blanket this thing wherein you are putting those officials or otherwise into. So that victimization would have happened. But still, Supreme Court gave an order in compliance, SBI. But why did SBI seek time? That is $1 million question. Now we have been watching, there have been many stories coming through, leaks coming through, shell companies and all those companies raided by CBI, ED. Those companies and those shell companies have funded BJP, Bharatiya Janata Party. I don't know. This is not the BJP, RSS we have come to know of late. Only an individual top to down issues order and everyone has to follow. Wisdom personified BJP, the leaders of the stature of Advani ji, Vajpayee ji, statesmen. I only hope if I am calling Vajpayee as a statement, my colleagues will agree. We never had statesmen. Ravichandran ji always keeps telling me, political leaders, they should rise beyond that. They should become statesmen. Only then the country will prosper. So I'll just show 2 or 3 to confirm. Official confirmation from the Supreme Court of India. And before I ask, so here is the information. SBI sends data on electoral bonds to Election Commission after Supreme Court order. I have picked this from the Supreme Court official website. The State Bank of India on Tuesday, 12th March 2024, furnished to the Election Commission of India, ECI, all the details of electoral bonds encashed by political parties since 12 April 2019. The data was sent to the Election Commission of India in compliance with the Supreme Court order of Monday, which had mandated that the same be done by 5:30 p.m. today. That means yesterday. The Supreme Court had also asked Election Commission of India to compile and publish the data on its website by Friday, 15th March 2024. Even Election Commission of India has acknowledged this, but now Election Commission of India, will it publish? Again, there should be another Supreme Court order. Meanwhile, it is shaming the Supreme Court Bar Association. Even hitherto, during farmers' agitation also, this gentleman keeps writing against the public will. And this is not going to help Bharatiya Janata Party. I hope Mr. Amit Shah and Modi understanding. If they are writing this way, this will reflect on the government's performance and duties only, as it has happened with State Bank of India. They have to cut a sorry figure. President of SCBA, Supreme Court Bar Association, writes to President Draupadi Murmu, stating electoral bonds case verdict be not given effect. He has become a laughing stock. SBI already in compliance released it to President of Supreme Court Bar Association writes to the President of India, Draupadi Murmu, that the judgment of Supreme Court in electoral bonds case be not given effect by seeking a presidential reference until reference is heard, the judgment be not be implemented. See, he's becoming a laughing stock. I think now the Supreme Court Bar Association should take a call on him that such good Bar Association should be coming to the rescue of people, innocent people, when advocates or, when they try to play tantrums. But instead, he is becoming a laughing stock. Now, this is another leak. In 15 more donors of BJP, they have already given prior a big list that I'm not trying to display. The latest one, 4 shell firms, 11 companies that faced central action. So they have all, they say, donated to Bharatiya Janata Party. Investigation a pattern. We have found 11 similar donors and money to BJP from 4 entities listed as shell firms. What we found, rupees 4.94 crore donations to BJP by at least 4 firms named as shell companies by SEBI. There is more. 11 other BJP donor companies faced central agency action during 2016-17 to 2022-23. They donated rupees 62.27 crores. Yes, from mega industries in Telangana, we have documented that also. Income tax raids, ED raids, no action. What happened? How that fellow is being allowed to go for contracts? Latest being Chandrababu Naidu. He has been fixed by Telangana High Court, stating that 850 acres of prime Telangana land has been donated or earmarked to a fake company. And the very same evening, Chandrababu Naidu and the popular star Pawan Kalyan goes and meets Amit Shah and Nadda. They stitch electoral alliance. What does this all mean? That means, are they getting such type of money from them through these electoral bonds? And same thing we have seen in Ajit Pawar in Maharashtra. This is not the BJP we have come to know. That's what I'm trying to say. SEBI's allegations, these companies allegedly misuse their funds or accounts. It is on record, SEBI. Me and Ravichandran ji, clearly we pointed out before she went to jail, he was very clear. She should go to jail and all the companies' list should be made public. That was the demand from this. How are they classified? What is a shell company? How are they? Already Ravichandran dealt it. Deep dive investigations like this take time. Okay, this is all. Election Commission confirms receipt of electoral bonds. This is the official information from Election Commission too. And then this is this release data. Now, to divert the attention from electoral bonds, they say Amit Shah and Modi trying to bring in CAA. Right, gentlemen? Now let's get into the discussion. Ravichandran ji.
Dr. Rajendran talk.
Yeah,
he'll give a better idea about why.
Because you are a banker, KYC is already there. What is the purpose of holding such information from public? Because public means we are constitutional authority and we are the voters. How can you not share the precious information? Who is funding and whom and how much? How can you not be transparent? Rajendran ji.
Good morning, Dr. Reddy Garu and my learned colleague, Mr. Ravichandran, who has been very vociferous, frank and bold and forthright in expressing his views. And good morning, Dr. Reddy, for giving me the wonderful opportunity to share my thoughts, I would say concerns. That's all. In fact, I am not such a tech-savvy person to comment about the technical nuances of how the whole thing happens. And nor do I represent State Bank, neither do I represent State Bank, nor do I represent the government or the RBI. But as a former banker, and perhaps in my capacity as whatever little I learned about the core banking scenario in banking or perhaps the KYC kind of thing, because the KYC is particularly one query which Dr. Reddy wanted me to clarify. Yep. Okay, so from these 3 angles only I'm going to talk, maybe just for about 4 or 5 minutes only. First, let me talk about the Supreme Court Bar Association's appeal to the President. I will not rather say that appeal itself is laughable, because as a stakeholder, normally every stakeholder explores all the avenues possible. Perhaps he thought when the Supreme Court itself can take another curative petition, a review petition, review petition may take some more time. That the curative petition or the review petition, that door also was closed. Perhaps he thought that one more door is there. Why not I President Murmu? It is just an appeal. So let us not come and criticize him just for making an appeal. That is one part of it. Okay. The second, we come to the purpose or the objective of electoral bonds. Supreme Court Chief Justice also during his comments on the discussions with the government and both the parties, he said that the purpose of the government's or the act is laudable, because when you want to tackle black money, it's a good objective, but this is not the way of doing it. So perhaps I also fully agree with Supreme Court stating in the view that the government has a laudable purpose of bringing back as much black money into the white money into the banking stream or the monetary network of RBI in this country. Whatever the steps we can take by bringing the black money into the white money bracket, it's quite laudable. And in the process, they introduced electoral bond, hoping that electoral bond is the result of a bilateral contractual obligation. Now I'm coming to the third point which I wanted to express now. As a former banker, I would say every customer opens an account with the bank with the confidence, with the hope and trust, because banking, especially, is a necessity of a trust. With the trust that my money with the bank is safe and my money with the bank is confidential. It is not a question of safety, it is a question of safety and confidentiality. And besides, in this particular electoral bonds, the Act itself very clearly states that if anonymity will be ensured. In fact, Supreme Court also in his Chief Justice and the other learned judges there on the bench, they use the word a selective anonymity or a complete anonymity, some of those phrases. So whether it is a selective anonymity or a complete anonymity, this anonymity anyway is assured, is a result of a contractual obligation between the banker and the account holder. Now, if Supreme Court by an order can tell the customer or can tell the bank particularly to breach that contract and come out with the details, perhaps I feel this may open up floodgates. Just for the sake of argument, assume there is a very big medical scam or a mediclaim scam in the country. Nowadays, we know that mediclaim policy goes to not just lakhs, sometimes crores also. And reimbursement do take place in lakhs and crores. In one such occasion, some scam comes out. This corporate hospital, which is a listed company in the stock exchange, as a connivance with this insurance company, and they pay the claims in the lakhs and crores. So this corporate hospital is bound to answer, bound to respond to the claim or allay the fears of its investors. Suppose such a case goes to a High Court or a Supreme Court. Then the High Court or Supreme Court says that the hospital has to reveal complete medical data, mediclaim of all the whoever has taken mediclaim, has to make it public. And the bank, can you think of the unenviable or the embarrassing situation on the part of the bank now? Now, bank is bound to the customer. So it is a question of the proportionality on the right to information of the investors and the right to protect the privacy of the person who is invested. So there are two things to it. Suppose the corporate investor shareholder have a doubt that their money is being donated to a political party, they have every right to question the CEO or the board, whoever takes the financial decision to invest in the particular political bond, isn't it? So their CEO or the financial director or the chief financial officer or whoever is empowered, he is answerable to the shareholders. That is a contractual obligation. Supreme Court could have as well gone into that obligation. You talk to your director, let your director answer you. Without going to that aspect, why Supreme Court should come to the bank and tell the bank that you reveal all the data? Suppose the same thing happens in the case of mediclaim or any such thing. Will the Supreme Court take the same yardstick, apply the same rule, and tell the bank, you publish the data of all the mediclaim policies, wherever the money has been paid in excess of, say, 10 lakhs or 5 lakhs or whatever. You publish the data of all the claims, publish the data of all these things. So the basic trust, the bilateral confidentiality in the agreement between the bank and customer, that is shaken now. People may lose faith in the banking system,
Right.
especially the public sector banking. So public sector banking are highly embarrassing situation. This is the only point perhaps I wanted to make. Thank you. Thanks for the opportunity.
But anyhow, you have opened the floodgates. Now, me and Ravichandran will work on that also. Mediclaim, it is a bogus claims. Many public sector banks means it is public money, and they borrow at the mortgaging public only. And here
Exactly.
yeah, because it is ultimately public. That has to be made very clearly public only. It is not
Exactly.
somebody's pockets money. And here,
Think of a situation when Supreme Court passes a similar order now, isn't it?
it has to pass, it will pass. Now we have opened the floodgates. As a banker, we welcome you. Me and Ravichandran, we will invite you to discuss that also. That's a big scam. But before I go to Ravichandran ji, you have to understand, we are voting. When you vote, as a eligible voter, you have every right to know who is funding you, from where this money is coming. Is it illegal money of any arms or drugs, or those companies raided by ED and all, quid pro quo? Is that money being donated to that? If that is the case, it is corruption, corrupt money, and we don't want to elect such type of party or candidates who believe in corruption. Again, once they get elected, they'll come back and they will help them at the cost of the suffering Indian citizens, voters, and their resources. Ravichandran Swaminathan ji, please.
Good morning to all of you. Good morning to Mr. Rajendran and Dr. Reddy. So, I was listening to Mr. Rajendran. So, he has made a couple of points. But before that, he has talked about mediclaim policy. In this electoral bond case itself, Chief Justice Chandrachud has given an example while discussing the doctrine of proportionality. And in that he has mentioned a government employee takes leave often, and there is an RTI inquiry, the right to information inquiry, asking how many times this a government officer has taken medical leave and the reasons for taking that leave. And this was denied. This information was denied by the CIC, and finally the case went up to the Supreme Court. When it went up to the Supreme Court, Chief Justice Chandrachud mentioned that on account of accountability and transparency, this information has to be revealed to the public because the government employee is being paid by the public, and they have a right to know why this government officer is taking leave so much. But there is a point of privacy as far as the government employee is also concerned, because his medical details cannot be revealed. Therefore, Chandrachud had clearly said that while the number of holidays that the government officer has taken may be revealed, the medical reasons for which he has taken leave cannot be revealed, and it should be redacted, which is fair enough. In all probability, if a mediclaim issue comes up and a scam is revealed, then in terms of accountability and transparency, the Supreme Court may order it in a similar fashion. They may say that the accounts may be revealed after redacting whatever is individual's privacy. So we will have to depend upon the Supreme Court to pass out such a reasoned order. As far as the electoral bonds is concerned, again, we have discussed this earlier also. There are going to be repercussions because of this Supreme Court order. Now, it is a question of right to informational, it is a question of informational privacy versus right to privacy of an individual. Here, if I take the path given by Mr. Rajendran, then the point is everything about me I can declare it as a individual privacy. Then no investigation can happen. All my details, all my private data becomes a classified secret. It will be as good as a state classified secret. And in a democracy, that is not healthy. Even in my book on a right to privacy, I have mentioned very clearly that the right to privacy of an individual is paramount. And if that right is to be breached, it can be breached only by the court under very rigorous or stringent conditions. If these conditions are not applied, then the right to privacy is breached. As far as the Supreme Court is concerned, it was the Supreme Court itself in the Justice Puttasamy case reduced the right to privacy of an individual from being a primordial right to a fundamental right. Once that decision was taken to reduce right to privacy as a fundamental right, then it is subject to a lot of constraints which can be given by the government because the fundamental right is not absolutely absolute. So with this in mind, now what has the electoral scheme judgment all about? First thing, the government played a sleight of hand, like a magician's trick. The electoral bond scheme was not introduced as an amendment, constitutional amendment. It was introduced as a money bill. And this was the biggest lacuna because the electoral bond scheme made alterations to the People's Representation Act, Representation of People's Act, the RBI Act, the Companies Act. And all these was unconstitutional. It went against Article 19(1)(a) as well as Article 14. This is what the Supreme Court has declared. And it is good because that is how it should be. Because a money bill will not be subject to the oversight of the Rajya Sabha. That is why it was brought as a money bill. If it was brought as a simple act of parliament or a constitutional amendment, then the Rajya Sabha will also have a oversight on that. And at that point in time, BJP was not having a majority in the Rajya Sabha. That is why it was brought as a money bill. Now, regarding black money, when there are alternative methods of collecting money like the electoral trust, why bring this electoral bond scheme at all in the first place? Then regarding KYC norms and bankers' confidentiality. In an investigation, if a bank has to reveal the details of an account, it has got to reveal the details of the account. Even a policeman can demand it. Now, in this case, since the basic premise, since the basic scheme itself is not legal, the Supreme Court was well within its rights to pass a judgment asking State Bank of India to reveal the details of the account holders. But I will object to it only under two conditions. Number one, Supreme Court should have passed this judgment in 2019, not in 2024. It has been sitting on the case for 5 years before passing this judgment. And that is wrong because in this case, justice delayed has become justice distorted. Now, between 2019 to 2024, when it was under the consideration of the Supreme Court, at least it could have stayed the sale of electoral bonds within this period. Now, having permitted it between 2019 to 2024, when it was under the consideration of the Supreme Court, this sort of asking the bank to disclose the list of donors is not in order. Is it legal? Yes, it is legal, but it is not in order. That is one thing. The second thing is generalizing the entire thing. That is wrong because corporates have got a responsibility to their shareholders and they have to reveal the details. But as an individual, why should my contribution to a party be revealed? This is directly impacting my right to privacy. And like I said earlier, it doesn't meet the proportionality, because doctrine of proportionality was mentioned by Chief Justice Chandrachud. Doctrine of proportionality may be applicable to corporates, but how is it applicable to me as an individual? Why should my contribution to a party affect any other voter's choice? And as far as the corporates are concerned, I have mentioned this earlier also. This electoral bond scheme does not serve the purpose because two things. It is a bearer bond, does not carry any name. It is a promissory note, it is a bearer bond. It does not carry any name. That means a benami, I can act as a benami for another person and send the money through. For example, just to give you an example, today, Jafar Sadiq can take the money given to him from the sale of drugs, and he can ask somebody else, XYZ person, to open an account with the bank, give his KYC details, and route that money through the bank to the promissory note. And this promissory note is given to some other XYZ party, political party, as a funding. In other words, this electoral bond scheme has assisted in laundering of money. And this is an illegal act. It comes under the PMLA. The bank is now an accessory to a money laundering operation. The bank has been made an accessory to the money laundering operation by the government. And for 5 years, the Supreme Court has kept quiet about it. What are we talking about? Are we talking, or to my mind as a citizen, to an ordinary citizen, a legislation, I am not attributing any intention to this. Legislation born out of ignorance, not considered because of apathy, because of lack of appreciation for the issues. And finally, when you give a judgment like this, then the entire process is compromised. The parliament, by passing the law, made a mistake. The Supreme Court, sitting on this judgment, made a mistake. And finally, lumping everything together and throwing, I remember the cartoon that I gave you, throwing out the baby along with the bathwater. This is what the Supreme Court has done. It could have read down certain portions of the act. It could have given protection to the individual donors. It could have done so many things, but it didn't do all this. And in this sense, the Supreme Court is grandstanding. Over to you, Doctor.
That's wonderful. I think you have made your points very clear. And this is what we have been reiterating time and again. Yes, sir. Rajendranji, anything you would like to add? In another way, this is laundering,
Yes,
laundering money.
No, I'm happy.
Your voice is getting distorted like the judgment, delayed judgment.
I do agree with one particular. It's okay. Is it okay now? Now reasonably okay?
Yeah. I want you to be
Is it okay?
clear and loud. You are a banker. Because you said it's black money, but black money is legalized, passed by parliament, unfortunately. Through SBI. See, banking. Public sector banks becoming tools for regularizing or money laundering.
But correct. Yeah. This point I was more concerned about, because the government cannot do it, cannot tell any private sector bank to reveal the names of the donors, reveal the names of the depositors, or anything like that. So it's an embarrassment for the public sector banking. Public sector banking industry, that's one thing. But one thing certainly what Ravichandran says is true, that Supreme Court, instead of completely sucking down, could have struck down some of these sections, or could have given time to the government to slightly fine tune it, improve upon certain areas. Like, possible.
That's fine.
These are
That's
all
fine.
the
But as a banker,
views
now as a banker, let me
that
ask you.
people express.
But no, as a banker, let me ask you, because you are also running a big organization called Digital something. You are trying to enlighten people. When banks are so well digitalized, technically, with superior technology, how is that SBI went to Supreme Court demanding time? Don't you think this is shaming a big public sector bank like State Bank of India? Now, how depositors will save now from here onwards?
Okay, Dr. Reddy, can I tell you something? When the Media Ethical Guidelines Act, the rules were framed and Right Act on February 24th, 2021, very big major corporate completely computerized the foreign companies. I think Twitter it was. Just come in the paper openly, let me name the company also. The judiciary, the judge only wanted the name of the Indian contact person, the Indian head of your company, his name, his email ID, his office address, 24 by 7 who is available. If it's 1%, or 2%, 3%. Very simple, small, yeah, 3 to 4 word document would do. And the judge gave 90 days to furnish this data to all the corporates. On Twitter, you know what he did? I think it was Twitter, only Ravichandran may correct me if I'm wrong. On the 89th day, they put up a person, they gave representation asking for more time. Asking for more time just
So,
to furnish the name of the Indian head, his name, email ID, and address, phone number, nothing more. So, these are generally
no,
what
no, that's what I keep asking
litigants,
you. No, no, when
what
you have a
the
techno, that means bank deliberately.
what the
Now,
bar, what the advocate, they take
Rajendran,
research.
now we have understood that bank deliberately was trying to withhold information to save some. Who is that one? Who is that black sheep whom SBI tried to save? But at the end of the day, they have become a laughing stock and they have exposed the party in power. Ravichandranji.
But I do not view it like that. No, 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 no. Really, I differ here. I not say that bank is trying to safeguard or protect or hide somebody. Any legal avenue available in the data, in keeping up with the contractual obligation, bank was trying to explore. That's all.
Sir, bank is supposed to
Curative
function.
occasion,
Sir,
putting up,
bank is,
presenting
sir, it is a public sector bank.
curative.
No, no, it is a public sector bank. It is a public money. And electoral bonds are meant for
Yes, sir.
being
Yes.
utilized to
Yeah.
in elections.
Correct.
Elections means people like you and me, we have to vote and we are a constitutional authority. How can you withhold information from me? Where is the transparency and accountability? This is what I was trying to dwell. How can SBI do that? Now it has paved way for clear-cut legal money laundering, which Nirmala Sitharamanji, my Prime Minister Modi or Amit Shah, and for that matter, all political parties. We are saying, me and Ravichandranji, we have been shouting, every political party has received electoral bonds. BRS local party, even the Tamil Nadu and DMK, and Odisha party, what is that, Biju Janata Dal, then Mamataji, they have received more money than the national parties. Ravichandranji, this is where all these parties put together, they were trying to defeat people participatory constitutional democracy at the end of it. 19(1)(a) or 14, they would directly affect the democracy. Yeah, Ravichandranji.
See, one thing, now you have been blaming public sector bank, State Bank of India for not giving the data. State Bank of India has given the data. Now, Election Commission of India is refusing to put it on the, saying that they require more time to put it on the website.
Yeah.
So, it is just a question of kicking the ball as far as possible. Keep kicking it down the line as far as possible till the elections are over, then who will bother about it?
Yes.
Because now the Election Commission of India itself will be appointed by the government.
Yeah.
And that appointed Election Commission of India will select the government.
Yeah.
So, I don't see anything wrong with State Bank of India delaying matters. After all, they are also part of the government.
Yeah.
If they go against the government, then tomorrow if there is an issue in State Bank of India, then government will not recapitalize it. You should understand that. And
Yeah.
you are talking about voters, information and all that. Okay, boss, all this information is on public domain. Tomorrow, if some party comes to my house and tells me, give me a vote, I'll tell him, You have taken 5,000 crores from the electoral bonds. So now instead of 2,000 rupees, you give me 5,000 rupees, I'll give my vote to you. After all, it is just a matter of price.
Okay. Oh,
It is just a matter of price. Your prices, your price and my price as a voter is around 2,000, 3,000, 5,000 rupees. That's all. The price of the State Bank of India managing director, it must be higher. And a politician, it will be still higher. The entire problem is because in a democracy, it is not only the government. We do not have a strong, responsible, educated opposition. This is the reason why all these things are happening.
Yeah, your point is well taken. So now this is the show for today. Will Supreme Court again intervene if Election Commission of India, the pampered appointed by the government, if it says no, we will not comply with your decision, it is not possible to publish it by March 15th. What will Supreme Court of India do and what will India do, citizens? Is this not going to affect, as rightly said by our learned guest, that every vote is being bought? When you say money, if you involve more money and more money, that means citizens or voters are going to become scapegoats. They are being bought as if in a commodity in the market, which is not at all good for the democracy. Supreme Court should have taken this also. How could they increase the ceiling limit, spending limit during COVID-19 itself, when in polls in Uttar Pradesh itself? That has not addressed it. By not addressing money, enticement of voters, Supreme Court, I think, has missed a fair chance to fix this case once for all, so that this corrupt money would never become an asset for any party ruling or opposition. Or here, the opposition being weak, we are facing all this. Do support DRTSPA channel, Citizen DRTSPA channel, and Environment People DRTSPA channel. They are all in larger public interest. Anyone can participate. We can debate. You can always differ. That is the beauty of democracy. Now we'll see whether Election Commission of India will host all that information provided by State Bank of India on its official website, so that elections can be held in a free and fair way. Still reminding Supreme Court, delayed justice is distorted justice, and how Supreme Court is going to get Election Commission of India in compliance to safeguard people participatory constitutional democracy. Thank you very much, sir.